The whole prosecution, it looks like, wasn't about the rule of law. It was about laundering tax money for their own personal benefit. That's what is being effectively alleged here. The big news this week highlighting the corruption behind the prosecutions of President Trump. Now, just to bring you back up to speed, in case you haven't been paying attention for the last 2 years, the Democratic Party is trying to turn the United States into a one-party state by eliminating the candidate who's most likely to oppose and be on the ballot if things are allowed to proceed against President Biden. That is former President Trump. They're trying to jail him, throw him off the ballot, and you know all of that. And of course, the vehicles through which they're doing it are this Jack Smith prosecution up here in Washington, D.C., prosecution in Florida over the fake documents case, and the prosecution up here in D.C. is trying to jail him for disputing the election. Fani Willis, a Democratic politician in Georgia, Fulton County, Georgia, is also trying to jail Trump and other innocents for daring to dispute the election, as is their God-given right under law. And then, of course, you have a Democratic politician, prosecutor in New York, who's trying to jail Trump on just, frankly, charges made up out of whole cloth in terms of the plausibility of anything illegal having happened. But the big news this week is that one of the defendants in the cases in Fulton County, his lawyer filed a pleading with the court that suggests that the corruption involved in targeting Trump, which is an abuse of power in my view, right? The politicization of our law enforcement and prosecutorial powers to punish your political enemies, which is, you know, something that no Republicans can suffer through if we hope to continue, is also marred by personal corruption in the targeting of Trump. And I guess that's no surprise, right? So the allegation is that Fani Willis, and by the way, the Fani Willis prosecution is really outrageous in the sense that, it's one thing, Trump's a big guy, right? And he can be targeted, in theory, he's a billionaire, and so he's going to be able to protect himself, in a more straight, without as much difficulty as some a citizen and citizens and officials in Georgia, in the political party, the Republican political party, and activists who were also being charged there. And so that Fani Willis prosecution is particularly abusive. And this was my first reaction to it when it first came out. I was up on our roof talking about it. Hey everyone, Judicial Watch President Tom Fitton here with the latest on the crazed indictment of President Trump down in Fulton County, Georgia. It's all about power politics. It's not about the rule of law. And frankly, there's a national Democrat conspiracy to try to jail Trump in the middle of the presidential election. 4 indictments in about 5 months. Who are they kidding? This is nothing but politics, and most dangerously, they're trying to criminalize core First Amendment speech. They don't want anyone to dispute elections, and if they don't like what they're saying, as they're seeing in Fulton County, they'll try to jail you, not only President Trump, but other people around him who are doing their jobs under law and exercising their rights as free people in the United States of America. I think any government official, both in Georgia, here in Washington, D.C., and up in New York, have a responsibility to shut down these craven and politicized indictments of President Trump. Our republic is at stake. I should play that every week. We should play that like 5 times a day, because it was true then and it's true now. And I'm going to get into where the other opportunities are to shut this down. But that's where we stand. But on top of that political corruption I'm talking about, there's this personal corruption as highlighted in this legal brief raised by the lawyers for Mr. Michael Roman, who is pushing back against the attack on him, who is, again, he's one of the defendants in the Fulton County case. And I went and looked at the brief, and what I try to do and share my views with folks on Twitter about what I read in terms of these legal briefs It's like, I'm not a lawyer. I've read a lot of legal briefs, though, and one of the things as a layperson, you read enough legal briefs, and you're trying to communicate with the public about what you're reading. You kind of you try to focus on what is in the public interest there. What are people going to be interested in? What are the important points? And I try to share that not only here, but in social media and other places, because we're just trying to educate people about what's going on. And I've carefully reviewed, and I'll just read from the tweet because I think it's important, because you're not going to get the full description or an adequate description from the big media. They have an interest in summarizing it in a way to minimize the scandal here. I've carefully reviewed a new court filing by one of the defendants caught up in Georgia Democratic politician Fani Willis's unprecedented scheme to jail Trump and other Americans for attempting to dispute the 2020 election. The explosive court filing alleges that Ms. Willis and her appointed special prosecutor Nathan Wade, who is helping direct the prosecution of these matters, have been having an affair and have in effect been using the controversial prosecutions to improperly convert tax monies, upwards of $1 million it looks like, for their personal use and benefit. The filing alleges ethics violations and potential criminal violations of state and federal law. The defense team for defendant Michael Roman also asked the court to dismiss the indictment and disqualify Willis, Wade, and their offices from any further involvement in the prosecution. And as I noted, it would be no surprise, given the obvious political abuse of power in these Get Trump prosecutions, that there would be also base personal corruption by the Democratic politician running this and her special prosecutor. The introduction, and this is what I read, of the astonishing legal brief, which could very well upend the whole prosecution, follows. And this is where I go into the substance of the brief, so bear with me here. The instant motion, and this is the introduction, my understanding is the attorney who filed this brief is well established and well respected in the jurisdiction there in Fulton County, Georgia. So Mr. Roman evidently hired a smart local criminal attorney who just did what she had to do to defend her client in terms of examining these conflicts of interest that could potentially place his rights under the Constitution at risk. So the fact that this brief was filed by this specific lawyer, I'm led to believe, is significant because this lawyer's reputation is so high within the legal community there in Fulton County. The instant motion is not filed lightly, nor is it being filed without considerable forethought, research, or investigation. Nonetheless, this motion must be heard as the issues raised herein strike at the heart of fairness in our justice system, and if left unaddressed and unchecked, threaten to taint the entire prosecution, invite error, and completely undermine a public confidence in the eventual outcome of the proceeding. There are fewer positions of authority in Georgia's justice system more powerful than an elected district attorney. The district attorney has incredible control and influence over the entire criminal judicial process, including the power to decide who and when to charge and how to charge them, which cases will get tried and which cases will be resolved, and importantly, the power to allocate public monies provided for the operation of the district attorney's office. Historically, there have been few checks on this power in Georgia, and district attorneys have largely been able to act with broad discretion in deciding how to utilize public monies and making prosecutorial decisions. This case presents a unique opportunity for this court to review this authority and determine if the district attorney has overstepped her legal discretion and authority, and whether she and the special prosecutor violated the law and their obligation under the Georgia Rules of Professional Conduct when they engaged in a personal romantic relationship that has ultimately yielded substantial income to the special prosecutor. The important issues raised in the instant motion suggest that the elected district attorney for the largest district attorney's office in the state of Georgia has used the instant prosecution to pay her partner a large sum of money that was originally allotted to clear the backlog of cases in Fulton County following the COVID pandemic. Normally, the district attorney's use of funds allotted pursuant to a county's prior approval would not be newsworthy or legally actionable, but this case is different. The district attorney sought additional funds from Fulton County to clear the COVID backlog, including making a detailed presentation to the Board of Commissioners in 2021, and she ultimately received those funds for that purpose. No, and she ultimately received that funding from Fulton County, but she has not used those funds for that purpose. She apparently has used them to prosecute this case. So even assuming that there were proper and could be forgiven, even within the contours of this prosecution, there is a separate and very important concern about her use of the money. As the layers unfold, it becomes clear that the district attorney and the special prosecutor have been profiting personally from this prosecution at Fulton County's expense. Instead of handling this case within her office, as she could have done given the influx of COVID money, she chose to hire a private special prosecutor to preside over the case. Once again, on its face, this was not earth-shattering and generally well within her discretion, but there are several important facts that distinguish this case from the typical one and which render the indictment invalid as a matter of law. Under Georgia law, the district attorney was required to obtain Fulton County's approval prior to appointing the special prosecutor to work on the case. The reason for this requirement is simple. It ensures that the district attorney cannot act unilaterally with regard to public monies and is subject to the control and supervision of the governing body, i.e. Fulton County, so that the public has confidence in how the money is used. Undersigned counsel has found no evidence that the district attorney sought or received such approval to appoint the special prosecutor from Fulton County. This is not a mere technicality. It is a requirement that the Georgia Supreme Court has held must be followed when a special prosecutor is appointed, and therefore a prerequisite for any special prosecutor's work on a case, including the instant case. Since the district attorney was fully capable of asking for authority for additional funding following the pandemic, then it is clear she knows how to do that. So that begs the question of why she did not do so with regard to the approval for the special prosecutor in this case. One could assume it was an oversight, but digging deeper, the potential reasons become obvious. As has been pointed out in prior followings, the special prosecutor's oath of office was never filed. While this may have been an oversight, it may have been purposeful, a specific attempt to shield from public knowledge the fact the special prosecutor had in fact been appointed without legal authority. Perhaps more important and enlightening, however, is the identity and qualifications of the specific person the district attorney chose to put in charge of the prosecution. I mean, this is quite the potboiler, isn't it, huh? This is quite the setup. The district attorney chose to appoint her romantic partner, who at all times relevant to this prosecution has been a married man. Admittedly, this is a bold allegation, considering it is directed to one of the most powerful people in the state of Georgia, the Fulton County District Attorney. Nevertheless, the district attorney's fame and power do not change the fact she has decided to appoint as the special prosecutor a person with whom she had a personal relationship and who is now leading the day-to-day prosecution of this case. Even assuming this type of nepotism might be forgiven in the abstract, a review of the amount of money that the special prosecutor has been paid by the district attorney and the personal activities of the district attorney and the special prosecutor during the pendency of this prosecution shed light on just how self-serving this arrangement has been. The court may be wondering, and for good reason, how do you know this? Why does it matter? And how do we know this? This is the next section. Open records requests to Fulton County. Oh, they're doing a little Judicial Watch work down there, huh? Open records request. FOIA can be your savior sometimes, especially if you're under prosecution, it looks like. Open records requests to Fulton County reveal that the district attorney did not obtain county approval to appoint the special prosecutor. Why would the district attorney not obtain this approval prior to appointing the special prosecutor? The special prosecutor has admitted his oath was not filed prior to work on this case. Why would the special prosecutor not file the oath? A simple administrative task for the lawyer. The special prosecutor is seeking a divorce in Cobb County and sought successfully to seal these records, hiding them from public view. Why would a private citizen such as the special prosecutor shield filings related to his income and spending from public view? While the filings in the divorce are sealed by court order, the legality of which is open to question. Information obtained outside of court filings indicate that the district attorney and special prosecutor have traveled personally together to such places as Napa Valley, which is in California, Florida, and the Caribbean, and the special prosecutor has purchased tickets for both of them to travel on both the Norwegian and Royal Caribbean cruise lines. Traveling together to such places as Washington, D.C. or New York City might make sense for work purposes in light of other pending litigation, but that work purpose could only be served by travel to this. But what work purpose could only be served by travel to these traditional vacation destinations? The district attorney and the special prosecutor have been seen in private together in and about the Atlanta area and have believed to have cohabited in some form or fashion at a location owned by neither of them. Well, I don't think you need to be a detective to read between the lines of that allegation, right? Sources close to both the special prosecutor and the district attorney have confirmed they had an ongoing personal relationship during the pendency of this special prosecutor's divorce proceedings. According to these sources, the personal relationship between the district attorney and the special prosecutor began before this prosecution was initiated and before the district attorney appointed the special prosecutor. I mean, if true, wow. I mean, just think of the implications of what I read thus far. They were seeing each other, they were romantically linked, and this Trump issue, this political issue, political decision to target Trump comes up, and she brings her romantic partner into the program and the prosecution, and the incentive for the prosecution is to pay her friend, who then pays for vacations for her. So the whole prosecution, it looks like, wasn't about the rule of law. It was about laundering tax money for their own personal benefit. That's what is being effectively alleged here. Undersigned counsel knows the special prosecutor and has researched his litigation experience. That research reveals that the special prosecutor has never tried a felony RICO case, and RICO is the big charge that they're charging Trump with and the others, including this defendant, Mr. Roman. The state of Georgia and the city of Atlanta had several lawyers who specialize in the prosecuting and defending RICO cases. Despite having access to these resources, why would the district attorney instead appoint someone who has never tried a felony RICO case, particularly in a case with such national significance as this one? The special prosecutor, based on his lack of experience in this type of felony, would not be qualified under Fulton County standards to be appointed to represent any defendant in this case, given the complexity of the charges. If the special prosecutor is not qualified to defend the case under Fulton County standards, then how is he qualified to prosecute the case? Is that why the district attorney did not seek approval for his appointment? If so, why did she seek to appoint an unqualified lawyer without approval to preside over this prosecution? Since being appointed as special prosecutor, the special prosecutor has been paid an estimated almost $1 million in legal fees. Of course, additional fees would be expected when private counsel is hired, but that would assume that they are not in a relationship with the district attorney and they were qualified to do the work they were hired to do. Almost $1 million. The special prosecutor's fees have been lucrative in comparison to any in comparison by any reasonable measure. The district attorney's yearly salary, including state and county supplements, is $198,266.66. And the total annual budget for the Fulton County District Attorney's Office for fiscal year 2022 was $31.5 million. The district attorney lobbied for additional money from Fulton County to hire lawyers and staff to clear the backlog after COVID. Why didn't she just use that money to hire qualified in-house staff to try the case? Why did she instead use that money to retain the special prosecutor? It's like Peyton Place down there, isn't it? Am I dating myself? I never saw Peyton Place, but I'm old enough to know the reference. As the world turns, rather than Dallas, it's Fulton County. Why is this important? The district attorney's failure to obtain the required approval to appoint a special prosecutor prior to him obtaining indictments against Mr. Roman renders the special prosecutor's service in that role a nullity and without effect under Georgia law. So the indictments he assisted in securing suffer from a structural and irreparable defect and must be dismissed. So they are asking for not only the dismissal of the indictments against Mr. Roman, but all the other defendants, including the former President of the United States, Mr. Trump. In light of the district attorney's personal relationship to the special prosecutor prior to his appointment as special prosecutor, his appointment created impermissible and an irreparable conflict of interest under Georgia's rules of professional conduct, which requires the disqualification of both lawyers and their respective offices and firms. The district attorney's apparent intentional failure to disclose her conflict of interest to Fulton County and the court, combined with her decision to employ the special prosecutor based on her own personal interests, may well be an act to defraud the public of honest services, since the district attorney, quote, personally benefited from an undisclosed conflict of interest, which is a crime under 18 U.S.C. 1346, as well as a predicate act which could result in a RICO charge against both the district attorney and the special prosecutor. So she's making allegations of criminal conduct here. Putting aside both the legal and ethical implications of their conduct also undermines the sanctity of the criminal justice system, erodes public trust in our judicial system, and would place them above the law. To allow this conduct to go unchecked by a powerful public elected official threatens to undermine the very principles of democracy that the district attorney herself claims to defend in this prosecution. It seems hard to believe that such a powerful person could escape scrutiny and accountability for such egregious conduct, simply because she believes she maintained a moral high ground and holds one of the powerful positions in the state of Georgia. This is particularly true since she has used that platform and megaphone it provides to tour the country, giving interviews in pursuit of a conviction. It is for these reasons and other important reasons set forth below that the instant motion is being filed. The actions of the district attorney, special prosecutor, are indefensible under the law and our rules of professional conduct. So when they reference rules of professional conduct, those are the rules that lawyers have to follow in order to practice. If they break those rules, their ethics rules, they can be punished, restricted from practice, and or disbarred. Ultimately creating a fatal and irreparable defect to the indictment against Mr. Roman and a conflict of interest that has tainted the entire prosecution. To allow either of them to stand above the law would be to invite and encourage the same behavior in the future. As Mr. Roman respectfully requests that the court grant the instant motion and dismiss the indictment in its entirety as to Mr. Roman. Mr. Roman also respectfully requests that the court disqualify Willis, Wade, and their respective offices and firms for any future involvement in the prosecution of the matter. So that was a little bit long. It was probably longer than I anticipated, but I think it was important. I mean, just look at that story of incredible corruption that I found persuasive. Do I know for sure it's true or not? I don't. But as I said, a respected member of the bar in Georgia placed it in the court record, knowing the allegations were so serious. She better be right. I think it was a female lawyer who did it, in making these allegations. And as best I can tell, Fani Willis hasn't responded publicly to this. Her special prosecutor friend hasn't responded publicly to this. Miss Willis has been since subpoenaed in that in that divorce proceeding involving her special prosecutor friend. But this highlights the base corruption, as I say, in these prosecutions of Trump. Now, I think the prosecution, as Greg Jarrett of Fox News has highlighted, our friend over there, Greg said it should be paused. They're asking for the prosecution to be thrown out. But certainly, given the gravity of these charges and pending allegations, I don't see how any of this process continues until it's resolved. So we'll see what the court does. Marjorie Taylor Greene, I believe, sent a letter to the district attorney, or excuse me, the attorney general for Georgia, asking for a criminal investigation of this. The feds, I would presume, would have an interest in investigating this as well, if they're being honest. So this is, I don't know how it's going to play out, but to me, if this is true, it's just another example of how President Trump is a crime victim. I mean, you had essentially crooks in Fulton County, if these allegations are true, using a specious prosecution of Trump to line their pockets and advance their personal romantic interests. And this wouldn't be the first time, right? It wouldn't be the first time. Remember Peter Strzok and Lisa Page, the lovebirds up in the FBI, who were colluding on the Get Trump effort while maintaining, I think they were adulterous relationship at the time. And that came out that they were not only in that relationship, but anti-Trump partisans, and they had been running the Trump investigation. At least Strzok was a key individual there, and in Hillary's investigation too at the time. And then he went over and was working in the Mueller investigation, and then they found the text messages, right? And they had to, Mueller kicked them off the team without telling anyone. Tried to cover it up, but eventually it was found out. We've gotten a lot of those text messages, and our pressure exposed a lot of what went on there. And we've got a great production of that. What was it called? I think it's called Lovebirds. We'll do a link to the video. We partnered with some producers out in California who did a live play, or filmed a play based on the Lisa Page, Peter Strzok case messages. But there was that sort of corruption, right? Involved in the Trump camp, the anti-Trump effort under Mueller and Obama and the deep state. And it raises questions about these other investigations and highlights the need for transparency in them. Judicial Watch is in federal court right now seeking the names of the team members on Jack Smith's team. Who are they? We want to know who they are. Is it full? The Mueller investigation was full of anti-Trump partisans, Democrats, almost all universally Democrats and leftists. And that, to me, is public information that should be shared as the American people judge any special prosecutor's operation, because they're supposed to be above board and restore confidence that the Justice Department, or inspire confidence that the Justice Department is neutrally and fairly administering the rule of law. But if the whole team is full of anti-Trumpers, obviously that is doesn't get you to where we want to be. Now, what Jack Smith is telling us is that we can't have the names of anyone who works for him. Oh, we can have the names of people who have been public, meaning if someone signed a legal brief. But the equivalent of an assistant U.S. attorney or U.S. attorney, because we don't want the names of the secretaries or the clerks and such. But folks who are substantial public employees who are in significant positions of power or of influence, why on earth wouldn't we have access to those names? Are there other Fani Willises and special prosecutor friends like hers on that team? I mean, Jack Smith's position is that he could have Michelle Obama working in his office, and because she doesn't sign any legal briefs, we're not allowed to know about it. So there's significant corruption afoot in Fulton County. The evidence is really quite powerful, as I described to you. And then there's the appearance, I would say there is corruption because I witnessed it in the investigation under Jack Smith. But on top of that, there's the added appearance of corruption in their desperate effort to hide basic information about their operations. Namely, who's working for them? Who are the key people working for them? They don't want us to know. So we're continuing to pursue that federal court case. And we're going to be pursuing these issues related to Fani Willis as well, as best we know how, under FOIA and the open records law in Georgia. So that's the story of the week. The case against President Trump in Georgia, and by the way, that case wouldn't have proceeded but for them working with the Justice Department, the Biden gang up here in D.C., and the Pelosi January 6th committee. They were all in on it. I want to know who knew what and when about this special prosecutor, don't you? This independent prosecutor. Her friend, that seemingly, according to this lawyer, because I've read, I have it in my head, I've seen stories about the relationship this person had with Fani Willis beforehand. So my guess is it was well known in the court and in the community down there about their relationship. Terrible, terrible corruption. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.